All right, welcome aboard, everybody. What we're going to try to do over the next few minutes here is cover both Chapter 4 and 5 in one kind of conglomerate type lecture here. Starting with civil liberties. Now, Chapter 4 is on civil liberties, Chapter 5 is on civil rights. They sound the same because they both have the word civil in there, but they're both different. Civil liberties are about protecting you as an individual from the powers of the government. So, your free speech, your privacy, and so on. Civil rights are about protecting you from discrimination. So, we'll talk about civil rights here before long. But first of all, if we're going to discuss civil liberties, we need to be able to cover what they are, of course. They are restraints on the action of government against individuals. They are largely granted to us by the Bill of Rights, which are, of course, the first 10 amendments. We've talked about the Bill of Rights a little bit this semester. We talked about how they had to be included for the Constitution to pass. Now, most civil liberties are pretty clear, right? Civil liberties are pretty clear because we want to have free speech. We want the press to be free. We want the right to bear arms. We want protection from unreasonable searches and seizures. However, they're controversial because they often pit desires against each other, like freedom versus order. Okay, we want a society that's free, and we want a society that's protected and orderly and safe. But you can't have one without sacrificing the other. Now, as certain things aren't terribly uncontroversial, certain things aren't terribly controversial. For instance, habeas corpus. Habeas corpus is in the Constitution. You should be tried fairly before you go to jail. We also, in the Constitution, prohibit bills of attainder. These punish people without trials. That's not allowed. And ex post facto laws. Ex post facto laws also unconstitutional because they punish somebody for doing something that was legal at the time. Now, you might illegalize later on something. You can't go back and punish somebody who did it when it was allowed. Now, some of these, do have controversial aspects, like the vaccination debate. There's a video here about mandatory vaccination, but we don't need to watch it. It's just an idea that should we vaccinate people? Should we not vaccinate people? Should the government mandate that we vaccinate people? I think most of us probably agree that we should vaccinate, but should we force parents to vaccinate their kids even if they don't want to? It's unclear whether or not parents have the individual freedom to do that. Now, of all the civil liberties we have freedom of the First Amendment has all sorts of freedoms in it. Freedom of religion is probably one of the most critical. Of course, this means that the American government is secular. Now, by secular, I'm not saying anti-religious. It means non-religious. There's a big difference between the two. Okay? Anti-religious means you're out to get religion. Non-religious simply means that you are not for or against religion. This creates what we know as the wall between church and state. But this is, of course, not strictly a wall. There's lots of exceptions between the two. There is lots of interaction between the two. Like if a church caught fire, a public fire department will roll out and put the fire out. It'll roll out and put the fire out even though it's publicly funded. So that's interaction between the government and religion. In addition to that, we have lots of instances where the government just gives money to Catholic hospitals. The government gives money to religious preschools. Most religious institutions don't have to pay taxes, so you don't have to know these exceptions here. But there are lots of instances where government and religion do work together. Now, the First Amendment is this whole amendment listed there in the top left-hand corner. Top left-hand corner has all sorts of stuff like establishment of religion, prohibiting free exercise thereof, abridging freedom of speech. We'll go through each of these. But it starts off with the freedom of religion. And if you'll read it there, Congress shall make no law respecting an establishment of religion. That is the first prong of freedom of religion. It's what we call the Establishment Clause. The Establishment Clause. Now, the Establishment Clause says that the government can't endorse an official religion. They can't establish an official religion. More simply put, the government simply can't act in any way that promotes or demotes one religion from the others. That's not allowed. Now, over time, courts have devised a test to determine if something is the government promoting or demoting one religion from the others. This test has been called the Lemon Test. Now, the lemon test has 3 prongs to it. It's not named after the fruit. It's named after a court case. You don't have to know that, but you do need to know the lemon test. Make sure you know it. It asks 3 questions of any law or any regulation or anything the president has done. The first question is, what about this law? What about this action of the president? Does it have secular intent? If there's any intent whatsoever to promote or demote a religion, you have violated the first part of the lemon test. Secondly, maybe your intent is fine, but there could be a primary effect that promotes or demotes a religion. Imagine in our town if I passed an ordinance saying nobody is allowed on your front porch without your permission. Now, I'm doing that to make your home safer, so that's perfectly secular intent. However, somebody like a Mormon or Jehovah's Witness could argue that by keeping me off your front porch, you are demoting my religion from the others. Now, do you agree with that argument? That's up to you, but you can kind of see how that argument comes into play. Lastly, we also have excessive entanglement, which is something that church and state must avoid. Excessive entanglement's unclear what exactly it is. It's kind of vague, but basically we're just asking a question with excessive entanglement. The question is, are church and state too close for your comfort? Now, over time, we've largely replaced the lemon test with the neutrality test. Is the law or presidential action or whatever neutral to religion? That's a lot easier to remember, but it's also super vague because what's neutral to somebody might not be neutral to somebody else. But definitely make sure you know your lemon test. Definitely make sure you know your neutrality test. Now, like I said, the Establishment Clause is just one half of the freedom of religion. The other half is the Free Exercise Clause, prohibiting the free exercise thereof. The government cannot interfere with the free exercise of religion. Matter of fact, if you have a religious practice, the government must do a reasonable amount of work to make sure you can do it. For instance, if there's a Muslim that has to get on his knees and pray in the direction of Mecca 5 times a day, the government's got to make reasonable accommodations to make sure that that they're able to do that. Now, this right is not absolute, meaning you don't get free exercise of whatever you want in your religion. The government, matter of fact, can regulate it. It can regulate it, but they have to have a compelling reason to do so. For instance, Santeria is the practice of animal sacrifice. The government can outlaw that. It is constitutional for the government to outlaw that because we have a compelling reason to prevent needless animal suffering. Use of drugs. You can't simply say I'm a meth user because I follow the religion of meth using. That is not allowed. The government has a compelling interest to keep people off guns. And terrorism. Obviously, there are extremists in every religion, and sometimes they want to hurt people who they consider to not be members of their religion. That is not allowed, obviously. It is not constitutionally supported by the Free Exercise Clause. All right, we also have free speech. Now, moving on from religion, we talk about free speech. This includes more than you think, not just what you say, but also symbolic gestures. Okay, what you wear, certain actions you take, money donated to political campaigns. That's protected as if it was speech because it's symbolic. Okay. Now, is the right to free speech absolute? Of course not. Matter of fact, there's lots of different kinds of speech that is not constitutionally protected, including the clear and present danger test, which, wait for it, is speech that creates a clear and present danger. You can't yell fire in a crowded theater. That's going to put people at risk, okay? Unless, of course, there is fire, in which case, please get out of the theater. But you can't just yell it because you think it'd be funny. You also can't talk people into breaking the law. You're not allowed to talk people into breaking the law. That's what we call, that fails the imminent lawless action test. You can't incite a riot. You can't engage, the government can outlaw obscene speech. It's just hard to tell what exactly obscene speech is. The court has backed away from calling really anything obscene anymore. And hate speech. In some places, you can't say down with all black people or down with all Jewish people or whatever. In some parts of the country, that's outlawed, and that's constitutional to do so. You can outlaw hate speech. It's not constitutionally protected. Many of you know this. While you're at your job or school, you don't have free speech. Your clothes can be strictly regulated. What you say can be strictly regulated. So what about free press? Because free press is very close to freedom of speech. Matter of fact, we're just talking about media outlets essentially having the freedom of speech. There are, so all of the exceptions that we had a moment ago with freedom of speech also apply to freedom of press. There are additional areas, however, where the Constitution does not protect the press, where it would protect you and I. That's in defamation of character. Largely, I can defame your character, because I'm just a guy, right? You can defame my character, you're just a person. If you're a media outlet, however, you cannot wrongfully hurt somebody's reputation. Mainly because media outlets have a lot more reach, right? Media outlets have access to tens of thousands, or in some cases, millions of people. So we protect citizens from defamation of character from the media. Now, you can defame somebody through slander, which is saying a false statement, or through libel, which is writing something false. So there's a difference between slander and libel. One is spoken, that's slander. The other is written, that's libel. So celebrities and press figures get slandered by the press all the time, but they are not able to sue the press with any regularity, and that's because for them, they have to prove actual malice in any false reporting. Public figures and celebrities get written about all the time. That's who the media reports on. So we protect the media a little bit more when they report about public figures. If they ever get something wrong, that's not enough for celebrities and public figures to automatically sue them. There needs to be actual malice, which means actual intention to hurt them in any false reporting. And we also get the right to assemble. We also get the right to petition. Matter of fact, if you were ever inspired to visit this website, you'll see a whole list of petitions. Moving on to the Second Amendment, we have the right to bear arms. Now, this is the right to bear arms right here, word for word. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. It has largely been argued that this creates... it has been argued occasionally that this creates the rights of states to only maintain collective militias, and that therefore the individual right to bear arms is not protected here. Of course, that's not supported by the courts, and it's not supported by public opinion. Both have concluded that the Second Amendment does protect an individual's right. Now, with that in mind, gun control is not unconstitutional. Okay? You can regulate gun control. There can be a federal ban on assault weapons because they're so dangerous. There can be universal background checks because we want to make sure we know who's buying guns. Certain felons cannot own firearms. Okay? These are all constitutional forms of gun control. However, with all things, you can go too far, including a handgun ban. Washington, D.C. tried to pass a ban on all handguns, and the courts considered that just a step too far. That gives us right to privacy. Right to privacy is mentioned in the Constitution nowhere. It is not mentioned in the Constitution. So if the courts have ruled that we have a right to privacy, and we believe that we have a right to privacy, where are we getting it from? Truth of the matter is, we are getting it from the Bill of Rights. Matter of fact, certain parts of the Bill of Rights. The right to privacy comes from several amendments. Starting with the First Amendment. First Amendment gives us freedom of religion. It gives us freedom of religion, saying that I don't have to believe what the government... I don't have to tell the government what I believe. Okay? I have privacy of belief. So since I don't have to tell the government what I believe, we have to assume that my religious beliefs are under the realm of privacy. Now, we don't talk about the Second Amendment. Instead, we skip to the Third. In the Third Amendment, you don't have the right to you don't have to house soldiers in your home in a time of peace if you don't want to. Okay? Now, this is logically assumed because this is logically assumed to imply that I don't have to open up my home to the government. Okay? This gives us privacy of home. The Fourth Amendment says I am protected from unreasonable searches and seizures, meaning I don't have to subject my person to the government. It is what we call privacy of person. And fifth, I don't have to testify against myself in the court of law, meaning I don't have to tell the government what I know. I have privacy of knowledge. Now, if you band all these amendments together, the Ninth Amendment allows you to create a new right. Now, the Ninth Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This creates, like a mountain in the fog, a right you may not see in the Constitution, but still does exist. Okay? The Ninth Amendment says, a right you don't see in the Constitution can still exist. And that's where we get the right to privacy. We band together those previous amendments, and we create a brand new right. We also get due process from the Constitution. And, the Constitution says a lot of stuff about due process to make sure the government doesn't just throw us in jail for whatever. For instance, the government says no person shall be held to answer for a crime without due process of law. Okay? You also can't be double charged, meaning you're protected from double jeopardy. You also aren't forced to testify against yourself. We just talked about that. You have the right to a fair trial. You have the right to a jury. You have the right to be informed of the accusation and confront the person accusing you. And you have the right to compel witnesses that would help your cause. And you have the right to a lawyer, legal counsel. Now, it's not clear who all due process applies to. Obviously, it applies to American citizens. But what about, prisoners of war from the War on Terror? Should the rights of American citizens be applied to them as well? It's not particularly clear. The Supreme Court has ruled that they do have access to habeas corpus, but how habeas corpus is employed differs a little bit for them than it does for the rest of us. So that's civil liberties. Let's take a little time to talk about civil rights. Now, like I said, civil liberties is protecting you from the powers of the government, protecting the individual's rights. Civil rights is about protecting individuals from each other, protecting us from the government as well, namely in the way of discrimination. So civil rights is equal protection under the law, no matter what demographic of person you are, no matter what category of demographics you are in. Any demographic can have claims that they deserve more equal treatment, such as women, such as African Americans. But really a whole list of these folks here, sorry about that, I went too far. A whole list of these folks here do get civil rights protections as well, to a certain degree. Now, as far as the African American experience is concerned, we always start off with the African American experience in Chapter 5 because they arguably have gotten it the worst in the experiment of America. Starting off, of course, the first Africans in our country were not exactly immigrating here. Africans that were turned into African Americans languished in slavery for centuries. Then, fortunately, but far too late, we eventually passed the 13th, 14th, 15th Amendments. And all of these are called the Civil War Amendments because they all promote civil rights here in America. Starting with the 13th Amendment. The 13th Amendment gives us abolition, where it says slavery is unconstitutional. The 14th Amendment gives us a whole ton of things, but we'll focus on the fact that anybody born in America are citizens and now get to enjoy all the privileges of citizenship. Can't have their life, liberty, property taken away without due process. The 15th Amendment gives African Americans the right to vote, or at least says they shall not be denied to anybody on the basis of race. Now, this was all pretty effective at ending slavery, really lousy, however, at guaranteeing equal treatment. At the time, the courts effectively said that while the government couldn't discriminate, private businesses totally could. No problem there, according to the courts. There was also a terrible ruling called Plessy v. Ferguson. It established separate but equal accommodations as constitutional, such as the famous pictures of the white water fountains versus the water fountains for people who weren't white. Same thing with public swimming pools. There were white pools and black pools. Same thing with schools. As you can imagine, we were very good at the separate part, but very lousy at guaranteeing equal resources and equal treatment. We also established several voting barriers as well. Let's talk about those briefly. Now, we erected several voting barriers against African Americans. Let's look back at the 15th Amendment here for a moment. 15th Amendment only says that you can't deny the vote. The government can't deny a vote to anybody on the basis of race. Political parties, however, are not the government technically, and therefore were perfectly allowed, according to the courts, to hold white primaries, where only white people were allowed to participate. What about the grandfather clause? You can totally vote, so long as your grandfather had. You can apply that to white and black populations, but since the black population, their grandfathers weren't able to vote since they were slaves, as a result, this was fairly effective at keeping black people from voting. Poll taxes were also very effective at keeping the black populations from voting, simply because the black populations typically didn't have a lot of money. Same thing with literacy tests. Many of the newly freed black folks were not educated, and as a result, they couldn't read. These are all different things that we kind of erected to keep black people from voting back in the 1800s. Now, courts over time did eradicate separate but equal, thanks to Brown v. Board of Education. This was about the segregation of schools. Now that's unconstitutional. Any school you go to must be integrated. Also, over time, each of these barriers we talked about, from white primaries down to poll taxes, have either been ruled as unconstitutional or amendments have been added to the Constitution to change them. Now, civil rights really kicked into gear in the 1960s. That's where you had the civil rights movement. Really two major competing philosophies. One was Martin Luther King, or I guess we'll start off with Malcolm X, since that's how my PowerPoint slide is going here. Malcolm X, his essential argument was that the country was built on a foundation of racism, and that as a result, white people don't want to treat white people don't want to treat black people the same because they believe they're truly superior. Our creator, however, disagrees, argued Malcolm X, and actually believes that black people could be the superior race, so therefore black people need to take what's theirs by any means necessary. Now that obviously is a little bit of a militant message compared to Martin Luther King. Martin Luther King was far more politically minded and endorsed nonviolence, something that we call civil disobedience, where you break the law nonviolently. That's the famous sit-ins, the famous instances of public displays of resistance. If you haven't had a chance to see Selma yet, by the way, I highly recommend the movie Selma. Very excellent display of Martin Luther King's civil disobedience in that film. Following the Civil Rights Movement, we got two major laws, the Civil Rights Act and the Voting Rights Act. Civil rights, these two laws illegalize discrimination on the basis of race. When it comes to getting access to businesses and employment. It gave the federal government more leverage against school districts and any other programs that are discriminating. It guaranteed federal protections to the right to vote. So now they were guaranteed to be allowed to vote. They couldn't be discriminated against in some of the ways that had been mentioned earlier. That said, of course, we still deal with segregation today. Now, we don't deal with so much de jure segregation, which is segregation by law. There's no real laws out there that say black people go this way, white people go that way. But we do deal quite a bit with de facto segregation, which is segregation by practice. A lot of housing units in the biggest cities. Ferguson, Missouri, for instance, is an example of de facto segregation, since black people were essentially funneled into that part of the city several decades back. Many of these face challenges today, but we don't need to worry about that. Let's talk about women's rights for a few. Women also started off in the newly born America with almost zero rights. You couldn't murder them like you could black people and be perfectly fine, but they obviously didn't have the right to vote. They couldn't work. Most of them couldn't work at a job, and so on and so forth. Now, the women's suffrage movement began in the late 1800s, thanks to Susan B. Anthony. About 50 years later, it started showing tangible results when the 19th Amendment was passed. 19th Amendment passed said, votes for women. They have the ability to vote despite any attempts to discriminate on the basis of gender. Since then, feminism has been a big part of our national conversation. It's important to remember what feminism is because it kind of gets a bad rap in our society these days. All feminism argues is that women should be treated equally to men. They should be paid the same. They should have the same access to goods and services that men do. They should be just as protected by the law as men are. And feminism scored a lot of victories over the years. We have Title VII that prohibits gender discrimination, Title IX that prohibits gender discrimination in education and government assistance. Women can now serve in the military. They have better avenues now to deal with sexual harassment at work, although far from ideal still. They have better avenues to deal with wage inequality, also still inadequate, but they've made strides in that regard. And women, of course, now have better political representation, which helps as well. Let's talk about a few other groups that have had to deal with some discrimination, including gay people. Now, the vast majority of American history has been unkind to homosexuality, but in the 21st century, we've really started to see discrimination against gay people crumble. For instance, they have the right to have relationships now. We had a lot of sodomy laws, which outlawed gay sexual relations for a very long time. That was even upheld by the Supreme Court for a long time, until it was finally overturned in Lawrence v. Texas in 2003. courts, and some state legislatures eventually legalized gay marriage across the country until the Supreme Court declared gay marriage a constitutional right in 2014 as well. Now, gay people also haven't been able to serve in the military openly until very recently. In the 1990s, they were allowed to serve so long as they stayed in the closet, what we call don't ask, don't tell, right? And now, as of 2011, they can serve openly. However, as far as work is concerned, there are no civil rights laws that protect gay people from getting fired for being gay. So that's really up to your state. And if your state doesn't protect you for being gay, then it's really up to your business. And one hopes that your business does protect you for being gay. I really encourage you not to work for a business that doesn't protect you from civil rights laws, no matter what your sexual orientation is. Other pertinent civil rights issues, you've read a little bit about undocumented immigrants. They have, should they have equal access to our laws? Should they have a right to remain here? Do they have any rights? Maybe, maybe not. Felons and prisoners, prisoners have no protection really against sexual assault. The rate of sexual assault in prison is ridiculously high. Do they have any protections constitutional protections that can ward that off? They are paid well below minimum wage when they're paid at all. Convicted felons who serve their sentences, have to jump through a lot of legal hoops to get the right to vote back. Is that fair? Maybe, maybe not. Now, abortion obviously concerns the unborn. Abortion is allowed. It was ruled in Roe v. Wade that abortion is a medical decision and therefore falls under the right to privacy. So what about the rights of the mother to make medical decisions? What about the rights of the unborn? We have two competing entities here that have different that might have different rights. So when is discrimination actually constitutional? True story, you are allowed to discriminate. You are allowed to do so. However, it depends what you're discriminating against. If you were discriminating on the basis of race or religion, you totally can do that so long as you meet what we call strict scrutiny. Got to have a compelling government interest. Like an example of strict scrutiny would be if I'm starting a program in an inner city with a very large black population to get kids off drugs. And the research shows that young, at-risk black kids will best interact with black adults, then I will hire black adults. That is discriminating on the basis of race, absolutely, but it's doing it for a compelling interest of keeping at-risk kids off drugs. You can also discriminate on the basis of gender. You got to meet what's called exacting scrutiny, which for some reason is not as intense as strict scrutiny. You don't have to have a compelling interest, just an important interest. Now, I don't know exactly what the difference between compelling and important is, but the courts generally regard as important as being less strict than compelling. You can also discriminate on the basis of sexual orientation. If you're going to discriminate on the basis of that, all you need there is a rational basis, which is just really any rational reason whatsoever. If I don't want to hire a gay person because I don't think my customers will buy things that a gay salesperson is selling, then constitutionally I am allowed to not hire a gay person. So let's take a moment to talk about affirmative action. Affirmative action is a policy that tries to guarantee in education admissions or job hiring special attention and compensatory treatment to disadvantaged groups like women, like African Americans. It is a very controversial law, and it's very controversial because it has been accused of being a form of reverse discrimination. But affirmative action has several things going for it. It's a guaranteed check against a racial or gender bias in the important realms of work and school. It's maybe we're not racist. I'm not sitting here going, boo black people, but we all carry with us implicit biases that are very real. And if that's the case, this is a fair standard of protection against them, you could argue. Now, like I said, we could argue that this is a form. We could argue that this is a form of reverse discrimination.
Your daughter.
Hold on. I'm sorry, I'm getting a call from my wife. Hey, wife, I'll call you back, okay? All right, so sorry about that, everybody. So like I said, we should be colorblind in our admission standards. Not doing so is reverse discrimination. You could always argue like slippery slope concerns. Slippery slope concerns would be anything like having quotas for racial minorities and women. So how far do we go from there? Do we also have quotas for sexual orientation? Do we also have quotas for disability? Do we also have quotas for different religions or non-religious or whatever? So this is our discussion on civil liberties and civil rights. If you have any questions, feel free to contact me. Good luck.